The Constitutional Court is set to hand down judgment, another important one at that. Today, the ruling is in connection with an investigation into funding for President Cyril Ramaphosa's 2017 ANC leadership campaign. The Apex Court will rule on whether the president misled Parliament about donations made to his Newzroom campaign. It will also rule on whether Public Protector Cyril Mkhwebane's investigation into the matter was within her jurisdiction. Judgment on the matter was reserved last November, you'll recall, after the court heard arguments from Ramaphosa and Mkhwebane's legal teams. Now, the president's lawyers argued that the campaign bank statements were not within the purview of the public funds and therefore outside Mkhwebane's scope. They added that the Public Protector's findings had no basis in law, but Mkhwebane's lawyers argued that Ramaphosa rose to high office through that very campaign. Well, for more on this story, we're joined now by our senior politics reporter, Ziyanda Ngcobo, who joins us from the Constitutional Court here in Braamfontein. Ziyanda, a very good morning to you. So the High Court, the North Gauteng High Court, some time ago, setting aside Mkhwebane's report into the CR17 campaign. A part of what they said, I just want to make sure that the public is reminded here, Ziyanda. They said that Mkhwebane and this particular case, it was quote-unquote hopeless on merits. And so my question to you is, what will the key arguments that this judgment will be centered on, you think?
Well, very good morning to you, Toli. Well, ultimately, this is about how a Chapter 9 institution, which also has rights within the Constitution, how this particular institution called the Public Protector's Office, regardless of whether it's Cyril Mkhwebane, Thuli Madonsela, or whoever is occupying that office, whether or not this office actually has the jurisdiction to investigate the funds and donations that are given during an internal political party funding process. Now, this becomes crucial because part of the arguments that Mkhwebane's lawyers made was that yes, the ANC might be a private entity, it's also a political party which then deploys its members into the public space, which affects us because they go into the government and they occupy the executive. And ultimately, the interests of an individual such as President Cyril Ramaphosa cannot divorce then his private interest by wanting to ascend into the ANC presidency, when ultimately that will also see him occupying the highest office in the land through the state. And so ultimately they are saying that what the Constitutional Court rather is going to make a determination on is how far the Public Protector's Office can go, Koli, but also, when it comes to the politics and the landscape within our country, as we seemingly are moving towards more coalition politics, is an obligation, and of course this was done before the Political Party Funding Act came into action, whether or not they have an obligation to declare the donor so that you as a citizen are able to scrutinize who is funding politicians, especially if they're going to be running on an anti-corruption ticket such as Ramaphosa. On the other hand, however, receiving a donation worth 500,000 from Bosasa, knowing or unknowingly that Bosasa had been looting funds from the state.
Mkhwebane's jurisdiction on this matter, Ziyanda, let's put that aside because I think you've explained that. Then take us into the far-reaching remedial actions of this particular report. When Mkhwebane concluded her investigations, she said that the Speaker of the National Assembly, that's Parliament, and the head of the National Prosecuting Authority must conduct further investigations. Do we remember what the High Court said around that specific issue?
Well, I tell you what, Oli, the High Court in Pretoria was scathing of Mkhwebane when it came to that for several reasons. You'll recall, Oli, that Mkhwebane said that there was prima facie evidence of money laundering when it came to the movement of the funds, because 500,000 was donated to Ramaphosa's son, Andile, and then that money moved to the Reatenda Trust. But the High Court found that one, Mkhwebane was told that Ramaphosa is not a beneficiary of the Reatenda Trust, but secondly, Mkhwebane quoted the wrong law. She used the wrong law to actually try and sort of pin Ramaphosa down. That's what the court said. They said that seemingly, and these are the arguments rather that Ramaphosa's lawyers made, seemingly that Mkhwebane was playing in the political arena and therefore acted in a reckless and a rogue manner by making that determination, and also saying that Mkhwebane fundamentally ignored advice from the Financial Intelligence Center, which ultimately is an organization that helps you find the money and follow the money, as it were. And they said that, you know, the FIC actually said that there is no evidence of money laundering, and that even though she still made that finding in her report, knowing that now the public protector's reports are binding on institutions within the state, saying that her findings were simply based on the wrong law, and she provided no evidence for what she was putting forward. I think, Xoli, what emanates from that and what's going to be spoken about here today is also in relation to that particular point. You'll recall that the EFF and investigations unit Amapungane also formed part of these proceedings. The EFF wanting those bank statements to be unsealed so that the public can scrutinize them, because ultimately whoever funds politicians also affects democratic order. And on the other hand, Amapungane arguing that the Executive Members Ethics Act, which is the code that members of parliament subscribe to, in its current form is unconstitutional, Xoli, because it does not obligate members of the executive to declare who has funded them. So that is another important aspect, Xoli, that I think will also shape then the nature and the manner in which affairs are conducted in another arm of the state.